right, let me try to be a judge and take over, okay?
Good. I'm gonna leave. I'm glad to do this.
So, where do we begin? So judges like to ask questions, so I have a bunch of questions to ask you, which will help me shape my comments and hopefully make it worth your while that you stay here at the end of the day to listen to my comments. And the answers I'm going to get from you will help me a great deal. But before I get to that, I wanted to let you know that I'm sitting here intentionally. I would rather sit up there, but I flew from New York 2 days ago, and my wonderful, caring wife, who just loves to always give me her colds, I call her Typhoid Betsy, just did it again. So I've been in bed for the last 24 hours, but the good Lord allowed me to get up this morning, and I think I have enough energy left to talk to you, but my ears are clogged, and my nose is clogged, and I don't want to talk about my head at my tender age, right? But by asking you these questions, you're going to help me, help you, to give you hopefully the value for your coming here today, and hope you're going to find this to be rewarding and time well spent. First question, has anybody ever read my book yet? Issued 2 weeks ago. One person. Good, I need to know the answer to that. Secondly, has anybody ever read or knows about the First Step Act? Lots of people. Does anybody know about Stephen May and his problems? Lots of people. Does anybody know that I was the United States Circuit Court judge sitting for the Ninth Circuit that wrote the dissent in that case that sent it to jail for life? Not a lot of people. Interesting. Well, I'm the guy, okay? And why did I come here today? For a number of reasons. First of all, I was told by Pat and Terry that they expected a lot of press coverage here, but I did not believe it would ever happen, because if you read this book, it's a toxic book. It talks about criminal justice reform. It talks about what's wrong with our criminal justice system. It talks about the Stephen May case. And there's maybe a tacit conspiracy that they don't want to touch it with a 10-foot pole. There is a détente, I kid you not, amongst the presidential candidates and the vice presidential candidates. Do not talk about Judge Block's book. Do not talk about sentencing reform. Why? Why? Because Trump, Harris, both supported the First Step Act. And now it's a political year. And nobody wants to be seen as possibly being soft on crime. So you'll notice that the commentators at the presidential debate did not ask a question about a second chance. Did not ask a question about the First Step Act. Did not ask a question about whether or not this incredibly important reform legislation should be extended to all the states in the United States. They will not ask a question at the debate on Tuesday of Walz or Clark or Vance. They have a tacit understanding that it's a verboten issue, it's a tacit issue, it's a toxic issue. Nobody wants to be perceived as being soft on crime. It's pathetic, but that's the realities. Notwithstanding that, I knew that there would not be anybody from the press here today, even though Pat, tried her best. But I came anyway. I came anyway because it's important for me to let you folks know in Arizona that you are not a voice in the wilderness. That people hear you, they understand you loud and clear, including federal court judges from New York, including the New York Times. I asked that be shown on the screen. Did you put it up at all, Pat? The article that Adam Liptak wrote last week for the New York Times. Long prison terms deserve a second look and a little humanity, judge argues. In a new book, Judge Fredrick, who has served for decades, urged courts to vindicate the promise of the First Step Act, which lets prisoners ask for compassionate release from their sentence. Now, can you do me a favor? I'm going to need some water because I'm kind of dehydrated. And also, last week, the Washington Post, the famous prison journalist, John J. Lennon, wrote this review of the book. A judge argues for expanding a Trump law that can free prisoners early. In a second chance, Fredrick explains how he decides which incarcerated people to release and argues that more judges should have that power. And we've had articles in Bloomberg, and we've had a lot of interviews. So you are not alone, and I don't want you to feel that nobody is hearing your pain and your angst. I wanted to come here to tell you how much I respect your organization, how much I appreciate what you are doing, how much I'm going to share with you the angst we all have in the resistance we have to overcome in our country, where politics is the order of the day, where emotionality controls it, but not the rule of law. I am not a politician. I am in charge of applying the rule of law. And I'm here to speak out about it, and I've written about it in this toxic book, if you dare to read a toxic book, right? So, I came here knowing that there will not be any coverage by the press, but wanting to respect you, and also how important it is for judges to be open-minded and to learn and always learn, and not just be hidden behind the cloistered walls in their chambers and be wedded just to books and not have a chance to be exposed to the public. And I'm so grateful I came here for that reason, in addition to many reasons. When I came here, I heard Professor Zabota speak. I learned an awful lot from her comments. I listened to your panel members. I learned a lot from them. I listened to Paul Dubling, and Paul, I hope I'm not one of those judges who you want to avoid. But you know, you are welcome in my court anytime you like. I want to see you in the Federal District Court in the Eastern District of New York. How you are capable to relating the complexities of the law and the vagaries and the difficulties that people have in expressing themselves about our legal system is extraordinary. And you have a talent that I wish I had when I was practicing law. But I did argue a case in the United States Supreme Court was changed the government of the United States many years ago. Okay, so aside from that, I wanted to show my respect for Pat and for Terry, and for all those who have family members who should not be in jail. Now, many belong in jail. Obviously, I'm not letting the doors open and let everybody walk out of the jails. But there's so many people who do not belong in jail now, like Stephen May, and I feel that it's important for me to show my support for those people, my empathy for them, and my heart cries out to Terry and to Pat, and the angst that they have to go through, and the many other people in this world, and maybe in this room, who have to deal with that same sense of inhumanity. And I wanted to share my thoughts. I was able to speak to Stephen yesterday, and I just wanted to tell you once again, before I go on and on, I'll try to go fast, but I may not be able to do it, that I spoke to Stephen May yesterday, and I shared my thoughts with you, that your voice is being heard in New York, your voice is being heard in the New York Times, your voice is being heard in the Washington Post, your voice is being heard in this book, which hopefully will reach thousands. Now, will it? I don't know, because while I'm very happy to see that we are getting this type of exposure, I know that there are efforts out there not to dignify this toxic book. Why do I know that? Because 2 days ago, Corinne Rainey from the Wall Street Journal called me up. She had an article, a very good reporter, she had written about me in the past, all about the Stephen May case and all about this. And the Wall Street Journal dished it. They wouldn't let her publish it. I know that. Amazing. I know that the New York State Legislature, a year and a half ago, proposed a law called a Second Look Act. And it's a great act. It allows what the First Step Act accomplishes on the federal level. And the leaders of the Senate did not want to put that up to a vote. Now, these are Democrats. Why? Because bail reform is a big issue in New York, and they did not want this legislation to be passed because it reflects perhaps in a way which politically was not something which would be appropriate, because they didn't want the public to think that the Democratic Senate in New York was soft on crime. All right? and Barnes & Noble. Even though on the back of the book, we have praise from Hakeem Jeffries, Larry Thompson, the former U.S. attorney under George Bush's regime, Gretchen Carlson, who you probably know, who sued Fox News, conservatives and Democrats, Republicans, all here. Grover Norquist, believe it or not, Cory Booker, Jeffrey Toobin, Brian Holiday, all telling people how important this book is, and Barnes & Noble decided not to put it in their stores. You can still get it on Amazon. And fortunately, there'll be an Audible that'll be coming out in a couple of weeks, which, I think is a big deal these days. I'm gonna need it myself, I'll tell you right now. So, I know that this is a toxic book. I know that it's a toxic subject. I know, and I did not expect anybody to be here from the press to cover this. They were told not to come. But not every state is like Arizona. Some years ago, I was in Oregon speaking before the legislature there, when I wrote a major decision about collateral consequences, which is a problem, still is a problem, and they changed the law. But I had a responsive audience there. Here I do not. But it's worth my while to come out to talk to the true believers about what we all think is important. And it's worth my while to come out here to tell you not to give up the fight, just like I'm not going to give up the fight. And this book is going to be read by thousands and thousands of people, I am sure. And I'm not here to sell books. There's two schools of thoughts about what judges should do. And I think, Paul, you probably know this very well. Judge Posner, years ago, when he sat on the Seventh Circuit Court of Appeals, he supported the notion that judges should speak out about things they know about, that they should share with the public and not keep it in pectora, not keep it secret, right? They have a moral obligation to share people what they know. And then there's the other school of thought that said judges should never talk at all. I may be criticized for talking today, who knows, right? That it's best that judges don't say anything. Well, you know which school of thought I subscribe to. I think there is a moral obligation for judges who know about the law, who know about things, who know about the second chance, who know about the First Step Act, to speak out about what they believe the public should know. I'm not a politician. I may be criticized for even speaking today, for all I know, possibly, but I'm not talking about the politics of this country. Politics, the problems we have with the second chance and toxic books like that is that we have to deal with the political realities. But good politics many times, and it certainly has in this case, makes lousy law. And we have to deal with the emotionality of people, the sound bites, immigrants, whatever, sex, this, that, whatever it is. People really have to get beyond that. And this book and what I'm talking about today suffers from those two problems we have in the United States of America. Let me take a sip of water, bear with me, and we'll continue. I feel like going back to sleep, actually. So, what we're writing about is mass incarceration. And I'm going to take the liberty of reading the introduction, since most of you people have not read the book yet. And I'm going to bear with me while I put my glasses on. Believe it or not, at my age, I have to wear glasses. Can you believe that? So it's going to be short. I can read fast. Let me know if you have a problem hearing me if I start to fade out. I'm a federal judge. On June 2nd, 2023, I let a murderer serving a lifetime sentence out of jail. Instead of dying in prison, he was now a free man. Pretty good opening to the book. The next day, I was vilified on the front page of the New York Daily News. I subsequently let other condemned men serving lifetime sentences out of jail. Why do they do that? Was it time for me, after serving 29 years as a judge, to retire? Or was it the right thing to do? A few years ago, Congress enacted a bipartisan sentencing reform bill called the First Step Act. Among its sweeping provisions was one allowing a federal judge like me to reconsider the appropriateness of a previously imposed sentence and to reduce that sentence even if the original sentence was lawful. The act went so far as to allow the judge to nullify a lifetime sentence and grant the prisoner his freedom, as I have done. Never has such power been granted to a federal judge. As of January 2024, 4,680 federal inmates have been released by federal district judges since the Act's creation. There will be many more by the time this book is published. It has changed the whole concept and landscape of sentencing in the federal courts, recognizing that condemned prisoners may be entitled to a second chance. And it has motivated me to write this book. Now, we have a mass incarceration problem in the United States. It's an embarrassment. We are supposed to be a civilized country. We have about 4% of the world's population and about 22% of the world's inmates. I'll say it again. 4% of the world's population, 22% of the inmates. About 1.9 million people out of a current population of about 330 million are incarcerated. No other country can compete with us in terms of our uncivilized way in which we deal with people who have to face up to difficult situations in the course of their lives. Now, on March 14th, 2023, listen to this, the Prison Policy Initiative, an independent research and national criminal justice reform advocacy organization, reported that, quote, at least 113 million adults in the U.S., and roughly 45%, have a family member who has been incarcerated. 113 million people. And 79 people have a criminal record, revealing the ripple effects of locking up millions of people every day. Well, we don't have any problem putting people in jail, but we have a problem letting them out, those who should not be in jail. We truly have a mass incarceration problem. Now, the First Step Act, wonderful, and it really has been revolutionary, and it has been praised by people like Neil Gorsuch of the United States Supreme Court. I like to, refer to conservative people, because otherwise people will say these are all just knee-jerk liberals talking, right? Who in a recent dissent wrote that the First Step Act may be the most significant criminal justice reform in a generation. Okay, but most of the jail population comes from the states. The federal prisoners constitute about 200,000 of the inmates, or roughly 10%. But we have a few states, California, District of Columbia, New Jersey, who have taken little steps to dealing with allowing their state court judges to reconsider sentences. But they're minor things. It's nothing like the ones we really have to deal with. The idea of letting a criminal out of jail before his full sentence has been served is politically charged, obviously. Arkansas Republican Senator Tom Cotton has blamed the First Step Act for making America less safe. He believes that if anything, we have an under-incarceration problem, and has referred to the First Step Act as criminal legislation. We have similar comments from Ron DeSanto and from Pence, but I am a huge supporter of the First Step Act reforms. So is Justice Gorsuch. I especially embrace that part of the act that gives me the discretion to reconsider a previously imposed sentence. I believe in the biblical concept of redemption, and that the First Step Act appropriately provides a path to allow a worthy prisoner a second chance to live a law-abiding life. But what about the roughly 90% of the prison and jail population serving state sentences, like Arizona? Logic dictates that they should also be given the same opportunity and a second chance that the First Step Act now gives the federal prisoner. But as we shall see in this book, they are not. I argue in this book that the state should follow the federal lead and enact legislation similar to the First Step Act. So, this is referred to as Trump's law because he signed off on it. It was enacted in 2018, which was not an election year. It had enormous bipartisan support. 87 senators voted for it. Senator Harris voted for it. And Trump supported it. I don't know whether he still would support it. And the elections that's coming up here, nobody wants to ask either of these people, do you still support the First Step Act? Do you still believe in redemption? Do you still believe in giving prisoners who do not belong in jail a second chance, like Stephen May? And do you believe that it should be extended to all the states of the United States like the state of Arizona, like the state of New York. They're never gonna be asked that question. They're never gonna answer that question. But it has to happen. It has to happen. Now look, in this book, I divided it into 4 sections. You're gonna like the book. I'm gonna take my glasses off now. I know you're gonna like the book. You're gonna find it interesting, it's gonna be riveting. So the first section, I talk about 6 cases that came before me this past year as a federal court judge for people who've been in jail for life. And they asked me to set them free. And I tell you about those 6 stories, but I don't tell you what I did, because I'm a dramatic person. I want to make it interesting to you people. I don't want to get this a dull book by a judge, right? The second part, I explained the First Step Act and how it had this bipartisan support by conservatives, by liberals, Republicans, and Democrats. It was the right thing to do at the right time, and it happened. I think it was almost a miracle, but it happened. The reason happened because, for many reasons, it was the right thing to do. But in any event, you can read all about that. I explained to you how that law came to pass, how Trump came to sign it, how it's controversial, and how it had bipartisan support, and what it's all about. To give people like Stephen May, who unfortunately is not in the federal prison, a second chance. The third part of the book, I tell you what Judge Block did. Did I leave them out of jail, or did I let them stay in jail? So that's my dramatic way of dealing with the book, right? And you're gonna have to, maybe you'll agree with me, maybe you won't agree with me. So you're gonna be having to guess what did Judge Block do? Would I have let that person out of jail? Would I have kept them in jail? So there's a bit of a drama. I think it'll make for a compelling read. And then the last part of the book, we talk about the states and why the states have to do what the federal government has done. Why New York State has to pass the Second Look Act that's sitting on the desk of the governor. Why Arizona has to do it. I don't hold out a lot of hope for Arizona, but it's the right thing to do. So, the book is divided into 4 parts, and you're going to enjoy reading it. But I want to let you know that at the close of it, I did this. And I'm going to put my glasses on again. Just bear with me. See, it's terrible to get to be 60 years of age. The 6 cases I've written about in this book make for dramatic reading. You're going to like it. But I have tried to use them also as vehicles for raising many issues that merit serious thought and debate about our criminal justice system, in addition to highlighting the failure of the states to embrace the First Step Act and the counterintuitive post-release collateral consequences woven throughout. Many other issues that trouble me, such as our ongoing mass incarceration problem. It's an embarrassment. The excessively lengthy sentences we mete out, it's an embarrassment. The efficacy of the death penalty, our schizoid gun and drug laws, the plethora of congressionally imposed mandatory minimums, the emotional but often irrational sentences imposed on those convicted of sex crimes, particularly crimes involving children, the trial tax prosecutors impose on a defendant's constitutional right to trial, the glut of wrongful convictions, the grant of absolute immunity accountable for their intentional misdeeds, the failure to hold prosecutors accountable for their intentional misdeeds, the overly punitive nature of sentences on the juvenile criminal, our imprisonment of the aged, often demented inmate, the failure of our Supreme Court justices to embrace the same canons of ethics adhered to by me and every other federal court judge, and the proliferation of death threats against our nation's judges. I've already had a bunch. Now, let's talk about the 4th part of the book. And that's all about Stephen May. And as you now know, I wrote the dissenting opinion in the circuit court decision that, has kept him in jail. Hopefully it won't be forever. And it's an incredible story that you're going to read. You can't make this up. When Paul Dooling reads this, he's going to be shocked. But listen to it. So I sat on the Ninth Circuit Court of Appeals when the case came before me. And Judge Wake of the District Court in Arizona granted habeas relief. And I was able to convince one of the other two judges, we sit as 3-judge panels, to agree with that. And Judge Freeland, and I both agreed that Stephen May, his case should be thrown out, that it violated the Constitution for lots of reasons. We wrote about it all. And then the government of Arizona appealed and asked for reconsideration, and Judge Freeland changed the vote. I don't know why. She's a decent judge. She's very thoughtful. I was shocked. But she felt constrained. Maybe she wanted to make sure she'd get on the United States Supreme Court. I don't know what her agenda was. Good person. She felt constrained after she wrote why she had to reverse her decision. While she had to reverse her decision, she ended it by writing a concurring opinion, which is amazing. I'm sure Paul Dooley never saw anything like this in his life. Here's what she said. While I certainly recognize the seriousness of child molestation, the evidence that May was actually guilty of the 5 counts of molestation he was convicted on was very thin. May's conviction on those counts was based almost entirely on the testimony of children who were the alleged victims. Yet, as described in my opinion, on her opinion, the testimony had many holes. The potential that May was wrongly convicted is especially concerning because he was sentenced to 75 years in prison, a term that all but ensures he will be incarcerated for the rest of his life. Now listen to what she wrote. She had the guilty conscience. Given the significant constraints on the scope of our review, on the habeas review, Paul, forget about it, right? We are not in a position to do more than decide the narrow question whether the proceedings in this case were so egregiously unfair that they violated the Constitution. I think that they did. But I agree with the dissent, meaning me, that this case, and in particular May's sentence, reflects poorly on our legal system. I repeat, I agree with the dissent that this case, and in particular May's sentence, reflects poorly on our legal system. Because of that, because she changed her vote, with a guilty conscience, Stephen May has been consigned to spend the rest of his life in jail. It's as wrong as can be. If it was a federal court, he would be out because he would be a prototypical candidate for the relief that the First Step Act now offers people. And he would be out of jail. There's no question about it. But he's in Arizona. If he was in New York, I don't know. John Lennon, who wrote this article, he's the famous prison journalist, is coming up for parole in 2029 if there was the First Step Act or the Second Look Act that the legislature passes in New York, he'd be out of jail. There are people who just deserve to be in jail. And by no means should I be interpreted as saying that I'm opening up the jailhouse doors, because when you read the book, you'll know that I don't do that. But certainly, you have to have compassion. Certainly, you have to have humanity. Certainly, you have to have the opportunity as a judge to revisit a previously imposed sentence which ought not to be applied anymore. So, I get to Stephen May, and I'm out here, and I'm happy that I met with Pat and Terry Borden. I wanted them to know that they had my support. I wanted all of you people to know that you have my support. And I received a letter. I'm going to end my comments with reading from it, but let me take another sip of water, because you haven't read the book, but you will. Just give me a break. If I wasn't 100 years old and just getting out of my sick bed, I would do a better job. I apologize. On January 9, 2024, I received a letter out of the blue from Stephen May's parents, Patricia and Terry Borden, thanking me for recognizing the injustice in their son's case. The opening paragraph stated, "It gave us and our son hope that an Arizona clemency hearing would prevent him from dying in prison." But the next paragraph was disheartening. Despite your compelling memorandum highlighting all the injustices in Stephen's case, the Clemency Board denied a recommendation to the governor for clemency. Now, I was disappointed but not surprised. As I had written in my second decision recommending that May be granted clemency, I wrote about that too. Given the nature of his offense, it is unlikely that the Clemency Board would recommend that the governor commutes May's sentence. It's politically charged. It involves sex. You'd say, no, you keep him in jail for the rest of his life, right? Accompanying the two-page single-spaced letter were 3 other letters that had been submitted to the clemency board. 2 greatly troubled me. You can't make this up. The first was from juror number 1, who believed during the initial deliberations that Stephen May was innocent and there was no evidence to prove his charges. Now, I ought to tell you back this. The jury initially was a hung jury. The case was very thin. You're talking about, at best, whether or not Stephen, intentionally or unintentionally fondled some children on the outside of the bathing suits. I'm not condoning it. And if he did, maybe he belongs in jail, and not for life. It's absurd. The average sentence for murder in this country is 20 years. In New York State, if you rape a child under 11 years old, it's a maximum sentence of 25 years. Stephen May, lifetime sentence. You have to be outraged. You have to continue to be vigilant, and you have to continue to work with me and the other well-minded people in this United States of America, and I think we have a lot of them, to make sure that justice triumphs, that the rule of law applies, and not insanity and emotionality. So, the jury came out, and they were hung, and the judge in Arizona discharged the jury, thanked them for their services, declared a mistrial, and said, well, the case will be set down for retrial sometime in the future. The bailiff came running into the courtroom. Judge, I just spoke to somebody on the jury that said they want to give it another chance. Well, the jury was dismissed, but the judge asked the lawyers, well, do you want them to do it or not? And the government said, okay, and then the criminal defense lawyer, Paul, where are you? Incredibly said, okay. He thought that he would get, an acquittal. But, he drew the black bead, and Stephen's in jail for the rest of his life now. I don't think that was effective counsel. I think it violated the United States Supreme Court. He didn't have effective consultation with his client. It was a knee-jerk reaction. He was perplexed by it and surprised by it, and he was wrong in doing that. So I said in my dissent. So this juror number 1, during the clemency hearing, which happened not too long ago, wrote that, quote, after the shock of being brought back into the courtroom and exhaustion of deliberating for such a long time, I felt pressured to change my vote. He was critical of the foreman, who had stated that he is a father and May was guilty just by being there. Nonetheless, juror number 1 had caved after the foreman, quote, delivered a riveting speech upon returning to the room along the lines of, we can do this, and he probably will only get a year or 2. Let's compromise and just do guilty on a couple of the counts. Unfortunately, he swayed the jurors. This was not the only post-verdict jury note expressing a second thought about the efficacy of a guilty verdict that I have seen during my long tenure on the bench, and I am loath to revisit a jury verdict barring extraordinary circumstances such as proof of jury tampering. I recognize the importance of closure and respect the jury's verdicts, but the May case was so unusual, and once again, as Judge Freeland ruminated, an innocent man may have been wrongly convicted, that I was struck by the guilt that this juror had carried with him 17 years after he rendered his compromised verdict. As he told the clemency board, to this day, it makes me sick to my stomach thinking about that case, and it makes me sick to my stomach. I understand the role of a parent is to protect their children, but I believe that those children were injured by their parents and the legal system, and not Stephen May. I asked this board, there's one good person on the clemency board. The others are politically motivated. They're never going to do this. They're never going to touch with the football because it's sex and it's children. I asked this board to recommend that the governor commute Stephen May's sentence to correct this injustice. God bless this person. One person in the system had the courage to stand up and speak the truth. I do not believe he deserves to spend the rest of his life in jail. I live with guilt that he had to spend any time in jail at all based on my weakness to adhere to the rules of the court despite the peer pressure of the foreman and parents in the jury box. So, my curiosity got the best of me, and I wanted to find out what the clemency board said. And they just, there's not much of a hearing. They're politically based. They're not going to do this. They're never going to recommend that somebody charged with a sexual molestation charge against a minor be given clemency. And even if it's something which is bizarre and absurd. He may belong in jail, maybe, but not for the rest of his life. It's just ludicrous. It's just ludicrous. The third member of the board agreed, everybody agreed, but the last member spoke in support of clemency. She concluded there was no evidence of sexual molestation, that she did not see Mr. May as a sex offender. She apparently had read Mrs. Gold's letter because she stated that May had issues that caused shaking in his hands. She commented that, I don't know that I've ever seen a case, considering all the letters that have been written, and that he was released for 4 years or so and then came back. Bear in mind, he was at liberty for 4 years before the Second Circuit reversed it. He voluntarily returned to go to jail for the rest of his life. You can't make this up. She further commented that all the good things he accomplished for the community while he was at liberty for those 4 years, and that he certainly didn't resist coming back to incarceration. She was in favor, therefore, of moving to a phase 2 commutation hearing where other people can come in and speak. I'm almost done. But this would never happen because the other 3 members simply voted to deny recommending clemency. As I finished reading these minutes, I thought once again about why the Prison Policy Initiative gave Arizona's parole system an F- grade. But I was particularly troubled that May's clemency application was doomed to fail because he did not comment on the abuse he allegedly inflicted on the children. He believed, as the juror number 1 and the 1 dissenting board member, that he was innocent. We now know that thousands of innocent people are wrongly convicted, and it is simply counterintuitive that they should nonetheless confess to and express remorse for a crime they did not commit as the price to pay for getting out of jail. So I ended my book, and I'm ending my comments with this. I hope that the 3 members of the Clemency Board who voted against giving Stephen May a public second phase hearing will not take umbrage at what I have written, but accept that we are all in the justice business and should always keep an open mind to revisit a previously rendered decision that may not have been providently made. I have done that, and I hope the Arizona Clemency Board will be like-minded. It's a privilege to be invited here to speak to you. Thank you very much.